Welcome back. Just before the break, Lutka Zimochek, who is a partner in our NPZ law group, and me, we were talking about H-1B visas and a lot of good information that was provided by Lutka. We want to continue the program further. There are a few other things to talk about H-1 visas. Okay, what about the students? Sometimes this a little situation comes when the students' OPT is expiring, let us say June or July, but the year, we didn't talk that before, the annual quota and the quota basis, the year starts from 1st of October and ends on September 30th. So the law says if you are changing from student or visitor to H-1B, you can only start working from October 1 onwards, and you must be in a valid status until October 1. Otherwise, there will be no change of status. They may still approve the petition, and that person may have to go back to India or other country to get a visa stamp. But you are changing the status, then you must be in a status. There is an exception in the case of students.
Yes, it's an OPT, automatic cap extension. And let's say you gave an example, there is a student whose OPT will expire in June, let's say.
Right.
So if the petitioner files timely on April 1st, he files an H-1B petition.
Why can they not file before April 1st?
It's not possible.
Why not?
They will reject the case, and then the applicant is going to be in trouble.
Because the law says that you cannot apply more than 6 months in advance of the start date. So start date is October, so you can only apply April 1 or afterwards.
Exactly. So if the student's OPT will expire in July and petition is timely filed, then it will automatically, his OPT will automatically extend until October 1st.
Correct.
So that's a good news for our students because it was not before.
Okay, but what is the validity period for H-1B visas?
Initially, USCIS will approve petition for 3 years, and then you can extend it for additional 6 years. Additional 3 years. So in total, it's 6 years.
But we have seen some cases when it expires, after the 6 years period expires, they can extend on certain grounds.
Yes.
Even if it's only limited 6 years, can go to 7, 8, 9, 10 years, and you tell.
Okay.
When?
It's very important to start green card application on timely matters. So it has to be 1 year prior to the expiration of the H-1B.
Correct.
So in 5th year, it's important to file at the latest, to file a green card application in order to benefit from the extension beyond the 6th year. So either you do have I-140 approval or your labor certification has to be pending for at least 365 days.
That's what I was going to say. That they are looking at, employer has filed a labor certification, more than 1 year has expired, or the labor certification was approved, I-140 is filed and even approved, but he cannot file the 485 because the visa number and that employment category may be a second preference, third preference, not available. So this is the law that a lot of changes have taken place since I started. So now it is possible for that H-1B whose employer has applied for a green card to continue to keep on extending. And also if the I-140 is approved, your extension can be 3 years.
3 years.
Otherwise 1 year at a time.
And it could be 3 years, additional 3 years until the time the applicant gets the green card. So that's a good news.
Okay, so let's talk about some bad things, but not bad things, that things that we don't like but happen. Audits. RFEs. What's the RFE and what's the H-1B audits also there, RFEs also there. And in that context, talk about also the place of employment. This is a violation. There are a lot of violations the consuls are looking at very closely. The immigration is looking at very closely. What kind of violations that take place?
H-1B is tied to the place of employment. So the certain city has to be stated, or county has to be stated on the labor condition application. Let's assume that the employer wants to move the employee, or there is an additional place. Let's assume that the employee is going to work at the secondary place as well.
They said in New Jersey initially, employer said, I want to send you to Los Angeles for 6 months. What happens? How can I do it?
Well, if the employer knows that he's going to transfer an employee to Los Angeles, then he should file a new labor condition application.
Right.
That's very important. He doesn't have to file a new H-1B petition, but if it happens after the fact, if he already transferred the employee, then he has to file amended H-1B petition.
And the amended petition is, you must go on the record on the amendment, because this way, I knew that in one case the ICE people went to Los Angeles to the employer's place, and a lot of Indians were working there, who the employer just sent them to, like the, when I said New Jersey was the headquarters, they sent them to Los Angeles, they arrested them, handcuffed them for number of days. So that, because there is no record, even if they did something, there is no record at all in immigration service that they had informed them officially. So it is very, very important, and unfortunately it's a bad practice. Then the other problem that I see all the time is called benching. Benching. Employer says, I don't have a customer, so take 3 months off, stay home, and then I'll call you when I get another customer.
That's definitely not allowed, and there's going to be an issue. It's a violation for employer. Employee is going to be out of status. I just want to point out that it's a different story if the employee requests unpaid leave or maternity leave.
Even that,
it's fine.
That's okay, but they look closely whether
They
it is
do.
a kind of matter of convenience. हिंदी में बोले तो आपस में बातचीत कर लेते हैं, चलो क्या होता है, what I say, the employer say, okay, don't worry, I'll don't, but they may come to know, and that's why the audits come in. In the audit comes in big problem. They want to go over all the documents, and whether they are paying the right wages or not, what they said that they will pay. They may ask for the tax returns of the employer, tax returns of the employees,
Job duties.
job duties. They say he'll be working as a manager, but actually he's doing something different.
Yes.
So I guess that we have few more things to talk about, but we are running out of the time. I think we have to bring this program to a conclusion today. We thank you very much, Rutka, for being with us.
Welcome.
But you're going to be with us again next program. So all of you, thank you very much for watching the program. Please keep watching us every Saturday at 1 p.m. on TV Asia only. Thank you.
Thank you.